There are different kinds of community property agreements. Some community property agreements are what I call a three-prong community property agreement. The main piece of that is on the person's death, everything goes to their spouse. So for a three-prong community property agreement, what it says is everything my spouse and I have is community. Its second prong says, and everything we ever get is community, even if it's an inheritance to one of the spouses, which typically is separate. So if you have a two-prong community property agreement, that second prong says everything that we get is community, no matter where it comes from. And then the third prong of a community property agreement would say, and on my death, everything goes to my spouse. That's all there is to it, without the necessity of a probate. So everything then is the spouse's. Three-prong community property agreements are not the type of community property agreements that we at ELG Estate Planning would normally use. Why is that? Because even if we want to avoid a probate, in our estate plans, we always ensure that there is an opportunity to protect assets if needed. So we typically use what's called a two-prong community property agreement. And what that says is everything that we have now is community, everything we ever get in the future is community, but it doesn't have that third prong. It doesn't say, on my death, everything goes to my spouse. Why do we do that? A couple of reasons. In our wills, we will include what's called an asset protection trust. An asset protection trust is there just in case it is needed. So let's say you have two perfectly healthy spouses and they have this two-prong community property agreement, and their will also says, hey, everything goes out right to my spouse unless my spouse needs asset protection. One of the spouses dies and the surviving spouse is in good health, they don't need any asset protection. So we use that two-prong community property agreement together with what the will says, everything goes outright, and we will avoid a probate because everything will go to the surviving spouse, but we also use what's called an affidavit of surviving spouse at the time of that death. No probate, just an affidavit. On the other hand, what if the situation is different? They were two healthy spouses, but they were both in a car accident. One of them died, and one of them, the surviving spouse, was left with extremely high care needs. Maybe they've lost the use of their limbs. Maybe they have a traumatic brain injury. They're just no longer independent. Well, we want to protect assets for that surviving spouse. We want to make sure that they will be able to use state benefits to pay for their care and not have to spend down all the money that they have and that their spouse had. So we will want there to be a probate in this case. That two-prong community property agreement does not interfere with probate and asset protection. The will of the couple said, each of them has the same will, and it says that everything goes outright to my spouse unless my personal representative sees that my spouse needs asset protection, in which event I want all the assets to go to the trust for the surviving spouse, the asset protection trust. So in the event of this car accident where one is killed and one is left in basically bad shape, what we will do is have a probate and have the deceased spouse's assets fund a trust, an asset protection trust for the surviving spouse through a probate process. So what a community property agreement can do is avoid probate, but not interfere with asset protection if needed, assuming you have the right kind of community property agreement and the right kind of will that has asset protection availability in it.